You are watching the LemonAid Podcast with Amar Law Group. Join us as we unlock the secrets and expert tips you need to know now.
Hey everybody, welcome back to an all-new episode of the LemonAid Podcast with experienced attorney Shalev Amar, where we cover lemon laws and how they protect consumers from defective vehicles. I'm your host, Mike Leon. In today's episode, we're going to shift gears a little bit, no pun intended, from cars and trucks to motorcycles, ATVs, and other off-road vehicles. These machines might look different, but when they're defective, the frustration and danger for owners are just the same. And Shalev's going to break this all down for us, as always. Shalev, so good to see you. Let's talk about this because I think most people think of lemon laws. They think it just applies to cars. So how does it apply to motorcycles, ATVs, and other off-road vehicles?
Yeah, good to see you, Mike. I'd say a majority of lemon laws do apply to motorcycles, that is state lemon laws, and some do apply to motorhomes. The thing is, most lemon laws only apply to the chassis portion of motorhomes when they do apply to motorhomes. They also have a weight limitation, typically a 10,000 pound weight limitation, and a lot of motorhomes are above that weight limit. So unfortunately, because of that, in some states, the state lemon law does not apply to motorhomes. Now, other than California, no state lemon law applies to off-road vehicles, unfortunately, and it doesn't apply to travel trailers or anything either, again, with California being the exception. And so what we're talking about as far as off-road vehicles are, ATVs, boats, things like that. And so with that being said, there is a federal lemon law that's nationwide, and it does apply to all warranted consumer products. So even if the state lemon law doesn't apply in your state to an off-road vehicle, you still have protection under the federal lemon law. And that also applies to states that don't cover motorcycles. And so the main difference between the state and federal lemon law is what you can get out of the case. The way you evaluate whether you have lemon is very similar. It's just, have you had too many repair attempts for a substantial defect problem under the manufacturer's warranty, or has your vehicle been in the repair shop for too long? But the main difference is what you can get. Under a state lemon law, you can get a repurchase or a replacement. Under the federal lemon law, what you can get is cash compensation with keeping the product. It's called cash and keep. Now, in some states, you can also assert what's called revocation of acceptance. That's typically against the seller, which then the manufacturer indemnifies, and that gives you the ability to unwind the deal. But the problem with revocation is it's a very difficult claim to prove, and you basically have to park the product and not use it, because if you've used it too much, that bars revocation. So in most cases, if the state lemon law doesn't apply, you can only get cash compensation. But the other positive about the federal lemon law is it also enables you to recover attorney's fees, just like most state lemon laws. So you could still typically get the help of an attorney on a contingency basis, meaning that the attorney's fees are dependent on your case being resolved successfully or settled.
So let me ask you, because we touched a little bit about defects in a previous episode. What kind of defects for these type of vehicles do you most often see that are prevalent in these cases?
Well, look, they can actually be pretty similar to cars, brakes, engine, etc., suspension. What's unique about off-road vehicles is, especially if it's a boat, there could be boat issues that are completely unrelated to what you would have with a motor vehicle. And also with motorhomes, you can have defects that are within the coach portion of the motorhome, kind of the living quarters that would never exist in a regular motor vehicle. Like you can have an awning problem, or you can have a TV problem, or a table problem, things like that. But at the end of the day, the analysis is still the same. Is it a defect in materials and workmanship? Materials meaning the what the product was put together with, and then workmanship, how it was put together. That's still the same. If there's defects in materials and workmanship, then you could be entitled to at least federal lemon law help.
Some riders, motorcycle riders, they may assume that their vehicles aren't covered. We talked about this in the first question, but how do you truly help people understand when their situation truly can count as a lemon under the law?
Well, as long as they have a manufacturer's warranty, they are at least covered by some laws, typically the federal lemon law, whether the state lemon law applies or not. And what you want to look at is, are you experiencing a defect, and is it being repaired too many times or for too long? That's what you need to look at. And if you have either of those factors, then you may qualify for legal help and for compensation.
So when a manufacturer in that scenario, they denied the claim now for somebody that has a motorcycle or an ATV, what are some type of the arguments that they usually make that people should be on the lookout for? And how do you help the clients address those arguments?
Most commonly, they will argue abuse because by their nature, these products are used off-road. So they can say, hey, you drove through a ditch, or you drove through a bunch of rocks, and that's what caused the damage. It wasn't a defect. Or you drove into water and there's water intrusion into the product. That's what's causing the problems. It's not any kind of defect in materials and workmanship. So most commonly, the defense that a manufacturer will bring up is, hey, you have basically abused this product in the way that you used it.
Shalev, I know there's that federal Magnuson-Moss Warranty Act, and then obviously you had mentioned about state lemon laws. When it comes to motorcycles, off-road vehicles, can you tell our listeners about the differences between these, or maybe even some of the overlaps between these?
Sure. Well, the Magnuson-Moss Warranty Act, that's what we call the federal lemon law, because it's just the easiest way to describe it, because it basically is a federal lemon law. In fact, a lot of state lemon laws were actually modeled on the Magnuson-Moss Warranty Act, because a part of the Magnuson-Moss Warranty Act only applied to full warranties, and it had different provisions for limited warranties. And so what state lemon laws did was basically rewrite the full warranty protections of the Magnuson-Moss Warranty Act into state law. And so there is a lot of overlap. The most common overlap is attorney's fees. Most state lemon laws allow consumers to recover attorney's fees, and the federal lemon law allows consumers to recover attorney's fees. The main difference when it comes to attorney's fees is, under most state lemon laws, attorney's fees are mandatory to the consumer if the case is successfully resolved or if they prevail at trial. And under the Magnuson-Moss Warranty Act, attorney's fees are not mandatory. They're within the discretion of the court. But as a matter of practice, typically they are awarded in court cases. And so in the out-of-court context, when we're negotiating, most manufacturers will offer attorney's fees if it's just a federal lemon law case, because how courts have ruled in the past. Another difference where it comes to attorney's fees is, under the federal lemon law, under Mag-Moss, only a consumer can recover attorney's fees. But under some state lemon laws, it's a minority, a small percentage of lemon laws, but under some of them, manufacturer can also recover attorney's fees. But there's only one state that I'm aware of, Colorado, where it's mandatory that loser pays. So if the consumer lost, they would have to pay the manufacturer's attorney's fees. In most other states where a manufacturer can recover attorney's fees, it's only if a frivolous or bad faith claim was brought, meaning a claim that wasn't legitimate, that should have never been filed. And so that's a very high threshold for a consumer to be at risk for attorney's fees. But yeah, that doesn't exist under the federal lemon law. Again, only the consumer can get attorney's fees. And luckily, in a majority of state lemon laws, only a consumer can get attorney's fees as well. But like I said, there are a small percentage where the manufacturer has ways they can get attorney's fees. Now, another overlap is, again, the way that you evaluate whether you have a lemon product or not. And that is too many repair attempts for the same defect, nonconformity or condition, or too much repair time. And that's got to be under warranty. One big difference is the time limit for claims and the coverage period for claims. So under state lemon laws, typically it's 1 to 2 years, and some state lemon laws have no mileage requirement, but most have 12 to 24,000 miles. Like that's the lemon law periods, and it's whichever comes first. So for example, if it's 2 years, 24,000 miles, once you hit 24,000 miles, so let's say you hit 24,000 miles after 18 months, then at that point, that's the end of the lemon law period. And then typically you would have 6 months to file an action in court. Under the federal Magnuson-Moss Warranty Act, it applies to the entire duration of your warranty. So that means if it's bumper to bumper, 3 years, 36,000 miles, 4 years, 50,000 miles, the federal lemon law applies to the entire warranty period. It's not an artificially lower time limit like under state lemon laws. Also, typically you have much longer to bring a Magnuson-Moss Warranty Act claim because it doesn't have a time limit written into the statute. So what courts have done is, the law at least implies that there has to be some kind of time limit for bringing a claim. So what courts have done is they've applied the UCC time limit for bringing a Magnuson-Moss Warranty Act claim, which is typically 4 years from when the vehicle qualifies potentially as lemon, from when the warranty has been breached. So that's a much longer time period. Now, there is an exception to that. Some RV and off-road vehicle manufacturers and even some boat manufacturers have placed an actual time limit within the warranty. And most often it's within 3 months of when the warranty expires. Now, we argue that that is legally invalid, and most states agree with that. One exception, though, is Indiana. And so in Indiana, they typically do enforce the shorter time period for bringing a claim for RVs and off-road vehicles, which, like I said, is typically within 3 months of when the warranty expires. But apart from that exception, typically you have much longer to bring a federal lemon law claim.
Shalev, for somebody who's listening to this and they've had a bunch of repeated breakdowns with maybe their bike or their off-road vehicle, what mistakes would you advise them to not make so that way it doesn't weaken their case?
The biggest mistake would be not to seek repair immediately when you're experiencing a defect, because then it gives the manufacturer a defense it would not otherwise have, which is that you are abusing the product. You're experiencing a defect with it, it's not stopping properly, or it has a harsh start, or it cuts out on you sometimes, and you're not getting the repair done immediately. Because then what they can argue is if you're allowing the defect to fester, it's going to get worse and worse. And then they can argue, well, if the vehicle totally breaks down, well, it's your fault because you didn't go to get the repair, because something that was a molehill turned into a mountain because you didn't seek the repair. Another common mistake is you're getting frustrated with your local repair shop that's authorized by the manufacturer, and you figure, oh, I have a mechanic buddy who has his or her own shop. I'm just going to take it there. And it's not authorized by the manufacturer. That could cause the warranty to be voided. So that's another mistake, should be avoided. The third mistake is to not get copies of your repair records. They're called repair orders, because if you don't do that, all of a sudden records disappear once an attorney's involved. And you don't want to get into a he said, or he said, she said situation. The records are the number one piece of evidence in these types of cases. So always make sure after every warranty repair to make sure to get a repair order.
Before the repairs, What advice would you give to that person listening to us right now? They're at the dealership, maybe trying to buy one of these vehicles. What advice would you give to them to protect themselves so they don't get stuck with a lemon?
I would say you need to look at consumer reports for vehicles. You need to look at online reviews. If there's a vehicle that has a lot of complaints, lots of problems, you might want to choose a different one. But always remember that you have rights. And sometimes what can happen with these off-road vehicles, especially RVs, they'll give you a stack of paperwork to sign, and they're basically saying, sign here, oh, this is that. And they're not telling you that some of the documents that you're signing are severely limiting your rights. Like, one document could be that you agree to all the disclaimers that are in the warranty, or you agree to only arbitrate your claim rather than go to court, or you agree to only litigate your claim in the state where the vehicle is manufactured, say typically Iowa or Indiana, where you might not, the law might not be as favorable for you as the state that you're in. So I would be very careful with what you sign. When you sign something, you're deemed to have agreed to it. And so when they're giving those stack of papers, read through them. And if something's really, like, for example, something I would not agree to sign is what I was just telling you. Something that would require me to bring a claim in a different state. I'd be like, I'm not signing that. If you want to sell me the product, it's without this document. And I would say oftentimes, not always, but oftentimes to make the sale, they'll be like, okay, you don't have to sign that. So just be very careful what you sign. You don't want to sign your rights away or limit your rights.
Yeah. Shalev, thank you for the time and insights as always. We truly appreciate it.
You're welcome, Mike. Thanks again for having me on.
And thank you to everybody out there listening to another installment of the LemonAid Podcast with attorney Shalev Amar. If your motorcycle, your ATV, or even your off-road vehicle keeps breaking down, remember, you don't have to accept it. Enough is enough. Do me a favor right now. You can visit lemonlawadvocates.com and put your state at the beginning. So for the people in Arizona, Oregon, Washington, Utah, Colorado, Minnesota, and New Mexico, make sure you put that state, lemonlawadvocates.com. For those of you in California, CaliforniaLemonLawAdvocate.com. And for those of you in Nevada, NevadaLemonLaw.info. Or you can simply call 866-904-2627 for a free lemon law evaluation. And with Amar Law Group's fair fee guarantee, you'll never pay more in attorney's fees than you recover for out-of-court cash and keep resolutions. Be sure to like, subscribe, leave us a review and comment. Share this episode with someone who needs to hear it. As always, I'm Mike Leon. We'll see everybody next time.
Thanks for watching. Be sure to hit that like and subscribe button and comment below.